Oslo Cancer Cluster, Norway Health Tech, and Norwegian Smart Care Cluster. And this joint project we have today, it's our goal is to sort of share and get a good methodology going on how we can engage and approach the financial community to the benefit of our companies coming out of Norway primarily. So between us, we have a mass of about 500 member companies. It's a very attractive pipeline. They all have international ambitions, so it's a very exciting space to be in. And if you want to learn more about our clusters, you can log into our websites and read all about it there. We also have a lot of good partners and supporters across the ecosystem. A bunch of them are visualized up here. So if you have any questions, you need any connections, anything, you just reach out to any of us and we will be sure to help you along. So with that, I think I am going to hand the word over to Hanne Mette from the Life Science Clusters, who will just give a brief introduction to the good panel of speakers we have with us here today. So Hanne Mette.
Thank you so much, Therese, and thank you to both the speakers and to all of you who are joining us today. We have had several visitors to the ecosystems from the investor side the last years, and Fredrik Lehmann, who's with us today, he's one of them. Karin Leire, she's also participated in our Investor Day in May, and the topic of IP, what is really a patent, what you need it for, and what is the value, is a topic that has been revisited many times. So building on that, we decided to give this seminar today together also with the patent attorneys from Able and Imray, who are also advising both to investors and to companies seeking investment on the patent side. So from Able and Imray today, we have Paul Brady, who is a specialist in chemistry biotech, Julia Coggins, a specialist in chemistry and pharma, and Tom Burt, a specialist in software and electronics. And as mentioned on the investor side, Fredrik Lehmann from Industrifonden, a specialist in biotech, and investor Karin Leire from Segula, a specialist in the health tech field. So with these very knowledgeable specialists in the panels, we hope that you will enjoy the discussions around the topic of IP misconceptions and the true value of a patent. So Paul, would you continue?
Yep. Thank you very much for the invitation to be part of this today. It is an important topic, as you've said, and one on which in which we hope we can provide some help to people. Very quickly about me. Yes, I'm a chemist by background, and I've been working in the pharma biotech field for the last 25 years. Most of the time probably working with originators, getting their portfolio together, but also maybe a quarter, a third of the time working with investors, looking at the portfolios of the companies. Just very briefly, Julia works in the same group as me. She's also highly experienced in this area. Tom, sitting next to me here, is a software and electronic engineer by background, and he works more with what people call tech inventions, which of course also comes into life sciences now. Moving on, so yeah, just to expand a little bit, so the topic for today and the reason we're here is that most companies in life sciences and the tech field realise that patents will be important for their business and that they need them to secure investment. And I expect most people on this call will have seen talks or talked with attorneys themselves in the past so that they already know what patents generally are. So we're assuming people have a general idea already. And companies appreciate that patents are going to be important for them. The challenge then is how to achieve the goal of making sure that your patents protect the commercial opportunity that you actually provide to the market or to investors. Quickly then move on. So, and it's here where we do sometimes see some misconceptions. And in particular, I think there can be a feeling that there is a one-size-fits-all of what one should be looking for in one's IP portfolio. And actually, it's a bit more nuanced than that. And depending on what your offering is, there might actually be quite different approaches to take. And I think these misconceptions, you might say, well, what does that matter? What's the problem? They can lead to misallocation of resources. So you're focusing time and money on things that might not matter so much, whilst at the same time, there are occasions when people miss opportunities. And it can certainly lead to people worrying about some of the wrong things. So from a patent attorney's point of view, I think where we see the misconceptions coming in, it's really that it's not that things that are being done are wrong, but perhaps the priorities are sometimes not being quite aligned with the commercial end view. And I think at that, I'll quickly hand over to the investors for them to give their introduction to what they see as the focus.
Yeah, thank you. So my name is Fredrik. I am a venture partner at Industrifonden, been there for a few years and have a long background in the biotech industry. So from an investor standpoint, of course, patents are crucial. Patents, if you don't have a patent, you don't have an investment. But I would say that when people comes to us for asking for investments, we approach patents in two stages. First, when we get anything that comes to our table, we make a first kind of quick screen sanity check. Is this even from a patent perspective reasonable or not? And if it passes that kind of hurdle, then we can actually look at the case. And then in the end, a few months down the line and a lot of work in between, then we make the final IP check before actually doing an investment. And surprisingly many companies actually falls off already at the first stage. So we don't even look at them because their IP has been a little bit different from the beginning. So Karin, and this is again to remind you that I'm only looking at biotechs, and that's a specific, there are different approaches for biotech and medical devices and diagnostics and things. So Karin, representing the other part, right?
Exactly. So I'm the person behind the cryptical name of Konferensrum Alfred. So Karin Leire, I am investment director at Segula Medical Acceleration. So we're a Swedish venture capital investor with specific focus on medtech. And for us, that encompasses medical devices, diagnostic, life science tools, and digital health. We follow the same path as Fredrik just described in the process with a light and a heavier IP review as part of a due diligence process. I think it's important to stress, though, that what you expect from the IP review actually differs depending on at what stage you intend to invest. So we invest at a stage around Series A or B, where we expect a maturity in regards to the patent strategy, and that will vary between the different type of companies. But it's an important brick in the evaluation of the company in terms of assessing if the company understands the patent environment to start off with. And then on the other end, it's also tied to the exit strategies, which funding rounds are to be done after we have engaged in the company, and that will affect what we accept in regards to maturity on the IP side. So yeah, I think it's important to stress that no case is the other alike. That's what we're going to get into in the misconceptions as well.
I think you might be, yeah, okay.
Yep.
I thought you were muted.
Right. So, right. So at this point, we're handing over to Julia for the first part of our first misconception.
Oh, sorry. I think I got. Can you hear me again?
Yes. Yep.
Good. Sorry. I'm in the woods in France at the moment, so that's the excuse for my poor reception. So the first misconception, which is probably not just related to investment, but one of the biggest misconceptions about patents, is that if you do have a patent or a patent application, you're free to use your invention, and that's just simply not correct. So a patent is an exclusionary right. So it gives you the right to stop somebody else carrying out your invention, but it doesn't necessarily mean that you've got the right to actually, commercialize and work your invention yourself. Next slide. I think there's some examples. So yeah, there's always the possibility of there being a dominating patent, and by dominating patent, that means that a patent that's come before yours, that's been granted, and it covers an aspect of your invention that your invention falls within. So there's some examples of this on the next slide. So the classic example, excluding sort of the areas we're working in, is if you invented the bicycle, which has got wheels in it, and somebody else had a patent to wheels, you couldn't actually sell your bicycle without having some sort of license or agreement with the person who had the patent to the wheels. Now, obviously more specific to the areas we're talking about today, if you invented a new, more effective inhibitor of a particular enzyme, even if the inhibitor itself, say it was a small molecule, was itself new, you may not be able to actually, commercialize that, or at least be able to do that with permission of the earlier right holder if there was an earlier patent for the general use of any inhibitor for that enzyme for treating the condition of interest that you would commercialize that for. Another one we actually get asked for advice on a lot at the moment is about antibody drug conjugates, because there could be an earlier patent covering the drug, the antibody, or even the linker that connects the two. So there can be lots of things that can affect your freedom to operate and whether you can actually go ahead with the sort of technology area that you're working in. So what can you do if you're worried about this? You can carry out a freedom to operate search, which sounds a little bit like a no-brainer when you come at it saying, well, if I can't commercialize it, what's the point? And it can be really tempting to do this very early on in your research, but actually, if you're still quite early stage in your company and you don't have that much resource, really doing freedom to operate isn't the best thing early on. It can be actually much more sensible to wait to do that later on. And as we've sort of talked about already, misallocation of resources is something that's easy to do. And actually freedom to operate is something that's much more likely to be useful and give a sort of a well-rounded, thorough answer when you're much further down or much more mature in the stages of your company. And that's what we find. A lot of companies will come to us to ask if they should do freedom to operate, and often our advice is, well, you don't need to do that yet. You're at an early stage, and an investor will carry out their own due diligence, and if they want to see that, they might pay for that themselves, so you don't have to allocate those resources to do it. Or actually, a freedom to operate at the stage you're at won't give the answers that you need. You need to wait until your project's more near a commercial goal, and then you can carry it at that stage. But I'll hand over to Frederick and Karen now and see what their thoughts on or about freedom to operates are, and when they think companies should engage in those.
Karin, you want to take a stab first?
Yeah, so I can take the stab in saying that you're right. You're right in the regards of the if I say it from our perspective, as we come in rather late, we even if the company has done a freedom to operate, we would still do our own. So but showing that you have done an FTO shows your engagement, right, in and understanding in where you're at. So from somewhere where we are at in our investment, we would expect it to have been done at a point in time, but that is specifically tied to us coming in rather late.
Yeah, and I can only agree. I mean, it's also, as you say, it's time dependent and timing dependent. If we do seed investment or even pre-seed investments, of course, then the patents that from the company are so newly submitted that not all the prior art might even be public yet from other inventions and other patents. So at that point, it doesn't even make, from a pre-seed perspective, it doesn't make any sense to make a full-blown FTO search because not everything will be out there anyway to find. So again, in the two-tiered approach, that early due diligence, we look at a sensibility check, just see, does this make sense? Is there anything obviously in the open space that could prohibit this? And then do the FTO if needed at a much later stage. So far we are aligned about the misconceptions.
So can I ask, would you prefer to have like a sort of two-tier approach? So at the very early stage, would you like it to be any FTO or some just very brief?
Yeah, I think
around, or is it a danger to do it at all?
I think we're using stage in two different ways here, right? Because one of the stages where we are in the stage of a due diligence, and the other is where is the company in the stage of development, right? Yeah. And to Karin says, if the stage of the company is in, Series A, Series B type of things, then usually they are so mature that they have done an FTO search. So that's the company stage. Whereas the due diligence stage, we don't do it early, we do it late, even in an early type of investment.
And that's also for the simple reason that when we ask an IP firm to do this work, then we actually carry cost, right? So that's also a reason why we choose to do it do the greater one in the later stage.
Yeah, and by the time you've got to Series A and B, the amounts of money you're talking about, FTO is a drop in the ocean compared to what it is when you're at pre-seed stages, where it's actually, it's going to be a big chunk of some of the money that you're getting in.
Oh, absolutely.
And it would always be something to have in mind. So you don't want to blindly go or even eyes open go into the middle of somewhere where there will be a freedom to operate problem. So it's something to bear in mind, but just how much resource to allocate to it is often the question, I think. Mm-hmm. We do often find that when we file a patent application, we will get a search on that, and that will be a patentability search, which is different from a freedom to operate search. But if things come from a patentability search that look like there'll be a problem, then you need to take account of those. And then I guess when talking with investors, have your plan in place for what you're going to do about it.
And we've actually found in the past when we've spoken, with our clients to investors, that that's quite a strong statement to make, that, we don't have any freedom to operate, but we've done patentability searches and nothing from our patentability searches have, flagged up anything that we think is going to be a freedom to operate issue. And so it shows you're thinking of those things in the broader aspect of freedom to operate. You've got a little bit of idea of what's out there already, and you're saying there's no red flags. And that's a cheap way of being able to say something when you get those due diligence type questions when you're going for investment.
Right. Well, maybe partly in the interest of time, should we move on to the next misconception? Right, so it's often considered that getting a patent is hard, and you will see some people on the TV, on their adverts, will say, patented, and that is usually true. And the question is, should you be impressed by that? So and this particularly comes up when you're looking at the portfolio of another company, you see they have some patents. Does that mean the company's doing well? Should you be afraid of them? Should you be impressed? And the question always comes down to, well, just what do these patents actually cover? Are they sufficiently useful And this was obviously in a bit of a different context, but Richard Feynman had a famous quote to say there's plenty of room at the bottom. And I think you can apply that to patents as well. In any area of technology, there will always be a yet more specific, a yet more precise way of doing something, which may well be novel if it's not been described before. And if it has an advantage, then may well have an inventive step, and you could probably be granted a patent for that. But then the question really is, well, is this very narrow thing actually commercially useful? And actually getting a commercially sufficiently broad patent that it will keep your competitors off the market, that can be more difficult. So it becomes an issue of looking at these patents in a bit more detail. So we would say, well, before being massively impressed by somebody's patent portfolio, the very first thing to look at is, well, are these patents still in force? Patent applications are published, and most of the patent databases you ever look are of the patent application publications. And in a patent application, before anyone else has considered it and examined it, you can ask for anything you want. And that may or may not be granted. And you need to carry out steps, as I'm sure you're all aware, through the patent application process. And if they're not carried out in time, the application will become abandoned. So are these patents still in force? If so, what is it that they claim? What do they cover? And then, of course, if you're looking in a commercial situation, thing to very quickly look at is, well, are obvious variants that might be used by competitors, are they also covered? So, and if the answers to these questions are yes, then this is a patent or a portfolio you should take note of. But you do need to go through those steps first. So we sometimes find that, just to round up, we sometimes find that some people are overly impressed by the existence of patents because they assume that getting a patent is hard, and sometimes it is, sometimes it isn't. So we pass over then to the investors for their take on this.
I can start with just a comment, also important to add to this, which is, I guess, the reality is it's not only about the number of patents, it's also about who's got the patents. So if you're in a space where there's a really big actor and where they have got more lawyers than you have employees, that's also something to, that's something to make sure then that all your question marks are straightened out, because that's simply a fact that you are in a worse position in such a situation. So it's not the number.
Now, I would also go so far to say that if someone comes to me with 20 patents or patent applications, I wouldn't be impressed as much as I would be depressed. Because patents, of course, they really don't cost anything to submit. Not even the PCT is expensive in reality. But once you're starting approaching natural phases and approvals of patents, then the cost of patents just goes up in a very, very exponential way. So what you're basically doing is that you're taking a big chunk of money and pushing them ahead of you, and nobody would like to do that. So I guess I think that the most amount of patents that you maybe want to have is one every year, one every 12 months. So you're submitting the next patent before you're making a hurdle of yourself of prior art. But anything more than that, you're probably going to burn a lot of money.
That's right. You want the portfolio to be in proportion to the products, and so each patent needs to earn its keep, earn its place. It needs to have a functional role in the overall business.
Absolutely. And I mean, when you come to this, sometimes we talk about the bomb mat of patent protection to really keep all the other actors away. That's basically what you do 1 or 2 years before an approval of a product. That's when you really start, getting crazy with all the patents. But most of the cases that comes to us are not 1 or 2 years away from an approved product in the biotech sphere. They are probably more 10, 12, 15 years away. So it's just the cost.
Yeah. Any other points on that? We'll move on to our misconception number 3.
Yes, this one's for me to take. So this is something I hear a lot. Your invention's in the software area, so you won't be able to get a patent, or more shortly, you can't patent software. Something you hear here, and surprisingly, sort of educated sorts from time to time. It's genuinely not true. There's many thousands of software patents granted every year all around the world. The reason it arises is because the law's complicated and rather misleading if you take it at face value. It does literally say in Europe that you can't get a patent for a computer program as such, but it just genuinely doesn't mean that. There's a nuance to it. And the law's also developing. It's largely settled in Europe, although the UK, there's recently been decisions about how artificial intelligence fits into this kind of thing. But there's been more movement in the USA, for example. But the changes are generally over where the boundaries lie. So what's at the edge of what you can or can't protect. There are lots and lots of software inventions that are uncontroversially patentable. So the kind of things which give you difficulty are business methods, which can be literally a way of running a business, but also say something that's a way of investing in the stock market or a way of picking better music recommendations, things that aren't about technology, they're more about a social or a business problem. And pure information processing tends to be difficult because it's too abstract. It's kind of a sort of a notion that you don't want to stop a scientist, like an academic in their office, sitting at their desk, shouldn't be caught by patents because they're just for thinking, that kind of thing. Whereas anything that interacts with the real world is generally going to be okay. It's a very broad rule. So if you've got a sensing device or a system software to control a device or a process, that's much more likely to be found patentable, even though the inherently clever bits might be in the software and even in how the information is processed in the software. The fact that it's tied to the real world generally means you should hope to be okay. Similarly, if things are related to scientific applications, which is probably the case for most people on this call, that's a very good sign because it's sort of patents about technology, not about shopping or something like that. So that's a good sign. And often, actually, the issue we come across is obvious, not sort of eligibility, but someone just has the idea, okay, there's an entirely standard thing to do. Let's write an app to do it, or let's write a computer program to automate the process. And the problem with that is it's obvious, often, not that it's not the kind of thing you can get a patent for. So what can you do about this? Generally speaking, I mean, I would say this, but I think it's the case. Speaks of Patent 10 who specialises in software, because the answer to what you can protect is often at heart just about what the different patent offices around the world like to protect and what they don't. And there might be a rationalisation after the fact for why they pick those things, but generally just get to know the kind of things they like. Another point around it is the difference is often how you define your invention or patent application, not what the actual invention is. So your invention might be something very clever you'll do with processing information to come up with a result. If you write a patent application that just does that, chances are you can't get a patent application for it because it doesn't do anything in the real world. Whereas if you take that result and then your patent application explain how you apply that to a real life process or a real life situation or the operation of the device, that kind of thing, then you can protect it. But it's about how you describe the invention in your patent application, not what it actually is deep down. And another point to notice is it's often too late to fix a badly drafted software patent application later, so you do want to get something else to do in the start. So yeah, I'll now pass over to the investors. I don't know, I'd be interested to know if this is something you come across software patents particularly, or if it's or not. So
I'm going to take a pass on this one.
And I can say that we absolutely do, and it's a direct screen out in the first phase if you have not considered patents. If you haven't considered your patent strategy, if you're a software company, because that shows that you're not mature, right? That shows that you don't know what you're doing. So it's this misconception is probably done by someone who is completely outside of the software area and makes assumption about something that they don't know. So I fully agree with you, Tom, in that you should work with someone who is an expert in the software area, similar to how you, as you choose your contract research organization that is to conduct the studies. If you work with a device, choose a CRO that knows how to work with devices and not only with pharmaceuticals, because you should make sure that you're wearing the right suit for your own company. So it's just for us. It's a question again about maturity, and it's to make sure to stay on top of what's happening, because it is an area where we all know that with our legislations it always comes a bit behind reality. So it's an area where quite a lot has happened in the last years. So if you can be wise and use the new things that come, you actually have a strategic advantage for your company.
There's actually a couple of questions in the chat box here, and I think we do have a couple more minutes before we need to move on to the next stage. So the first one, this is from Jamie Kumari Livia. So how do you make sure no one is using your patented software algorithm? Monitoring sounds expensive.
I mean, I think this is true. It is one thing to bear in mind is, will a patent be useful? What are you protecting, in the sense that, is it protecting? Are you ever going to know if anyone's using your core process? And that is something to consider, I would say. I mean, it's, to a certain extent, yeah, I mean, I think you would decide whether it was worth filing a patent application for something if you were going to be unable to monitor it. Beyond that, I think it's the same as other types of invention, really, in that you would want to keep an eye on what your competitors are doing in the way that that's sensible. And yeah, it's I don't know if it's particularly. It's trying to think if it's unique to software or not. But yeah, I mean, it's something I would go through when talking to someone would be the question of, is it worthwhile filing this patent application? But I think I do that when I'm doing them outside the software field as well. So.
And actually, there is a bit of overlap there with the second question that's on the chat from Igor Shevkrinov. Regarding software, how can I patent the algorithm, which is the core of the business? Can it not be copied easily after it appears public? Is it not better to keep it as a trade secret? Which I guess that's the balance you're just talking about.
Yes, really. And I think, I mean, I suppose the point is, if it can, the whole point of patents is to stop people taking your invention and use it. So it may be easier to copy it, and that might be exactly why you want a patent, so as to stop them. And the point around trade secrets, I mean, yeah, trade secrets are a way to protect. So, I mean, any type of invention, the question is, how easily is it going to get out into the public domain anyway? Will people be able to find it or reverse engineer? Or will they come up with it independently? So patents, it is, yeah, it's the constant. It's the same question for patents. Generally, I think it's like, in return for telling the world how to use your invention, you get protection, and it's a balance for a trade secret, whether trade secrets are about protection, presumably for sort of processes that you would have as well.
Yes, I think with a more standard pharma type invention. In the end, you are going to have to tell the world exactly what your drug is. So that will always get into the public. So that is something you need to protect. Just how you made the compound, not every step of that would necessarily get into the public domain. So if you have a new improved process for making a new drug or an old drug, there is that balance. Is it worth telling the world about this new manufacturing process? Or are you better keeping it to yourself? So that is a consideration across the fields. say. It perhaps does come to the fore a little bit more with software, perhaps because it can be copied once a particular item is out in the public. But in principle, it isn't any different.
Fred,
I hope.
Sorry. How do you value trade secrets? Because we do often write, when we're dealing with investors on behalf of our clients, and we write up about their sort of trade secrets that they've got and summarize those and summarize some maybe the data exclusivity they have, or not data exclusive, but the exclusive data they have that sort of helps them, arrive at some of their results, and that's proprietary to them. How do you value that when you look at a company?
Well, we look at trade secret with the eyes of can this be patentable? Because we in biotechs we don't invest in trade secrets. We invest in patents.
And also getting into reverse engineering type of thinking. How easy is it then just to get around this and miss the value?
And I mean there is always the easy part of being just a tiny little bit too sure about your own greatness and say nobody else will ever invent this because I'm the only one who has the specific knowledge yet that therefore we should have it as a trade secret. But there are so many people around the world working on these type of areas that we are in now, and they don't even have to be brilliant. Sometimes they just have to be lucky, and there are a lot of lucky people around there, and some of them happen to be brilliant as well. So I wouldn't go down an investment path on the trade secret. It has to be a patent.
And also going further down the line when you were to talk with a strategic investor, they don't even want to, or a big manufacturer, they don't even want to risk getting something into their portfolio that could actually harm the rest of their portfolio. They wouldn't even then look at the case.
So of course this might be very different for different areas, but at least in the biotech sector, the good thing about trade secret, if you wish, is that if we can patent them in a year, then we are saving 1 year of patent life that they haven't been patented already. But they still need to be patented and patentability along the line.
So that's where I started with the, with depending on what you expect will happen during your time of investment and what you then can accept to be the status when you enter, because what you're evaluating for is when when we expect to see an exit, what it looks like. That.
Absolutely.
Great. Great. Thank you for the thank you, Igor. Right, so if we move on then to the next misconception we come across, we'll pass over to Julia again for this.
Right, so the next, we've already actually covered a little bit of this, is misconception can be that you need to file many patent applications and you need to file them early in your development work. And there are reasons to do this. So you need to file any patent applications before you've made your invention public to be able to actually get the patent granted. I mean, there are always some exceptions. The US has a grace period of a year, but really, if you want to get anything granted in Europe, you need to file before you've made any publications. And there can be a push if you're working with academics that you need to publish early, and therefore that leads to you filing your patent applications earlier than you might otherwise do. Another positive for filing early is that when you speak to investors, you can point them to your published patent applications, your positive international search report, and that can make you look more investable. So there are positives. It also makes some discussions a little bit simpler. So if you're going for investment and who you're talking to wants you to sign a non-disclosure agreement, sometimes it's nice to have that patent application already filed in case something goes wrong with that agreement, or when you're talking to manufacturers or anything like that. So there are pros, but the other side of this, the negative for filing early and filing too early, is that patents are limited to a 20-year length. If you file too early and your exit strategy is very far down the line, or your commercial product is very, very far down the line, your patents are going to be almost expired by the time you actually get to launch something. And so that's a real issue. The other issue is it brings forward the publication. So you've got 18 months from filing your patent application to your application publishing. And that can limit the possibility of you being able to file other patent applications that build on your core technology. So either that means you need to file those within that 18-month period. So you've pushed forward and you might have to file those patent applications before you're actually ready, before that next step is there, and actually your patents don't have quite the right data that we needed to support them. It tells your competitors what you're doing, earlier on than you might actually want to do. And the major thing is it's bringing forward costs. So Frederick's already mentioned this exponential cost rising. Well, yeah, you can filing an application is not that expensive. Filing your PCT is not that expensive. But once you get into the national phase, if you want that patent application to go forward as a grant in a lot of countries, your costs are going to rise. And that's at a 3-year time period or 4-year time period from your initial patent filing. So you're really bringing forward all those huge costs. And if you've not got that money coming in at that stage, you're going to have to make some difficult decisions, either to cut the patent entirely or only go ahead in some countries. And we'll talk about that in a little bit more detail later on. So really, it's a balance. And when Frederick spoke before about you not wanting to have too many patents, that is the issue. If you start filing early and you've got too many, these costs are just going to come and really blow a lot of budget. What you can do to help this is you can have a discussion with your patent attorneys, and these timelines are all very predictable. So we know from you file a patent application exactly when and what these costs are going to be. So your patent attorneys can give you a 12-month, 2-year, 5-year cost estimate for a patent portfolio, depending on how many patents you've got and the countries you're interested in. And that can actually be really useful to planning, taking a step back and actually really planning when you want to file your patent applications, and being sure that before you do that, making sure you keep everything, all the data, all the information within the company, and it's not leaked out, it's not made public, and you can plan for that. So that's the kind of major thing that you can probably do to help you with the planning stage for your patents. But yeah, it'd be good to see what Karen and Frederick think about how many patents to file and when to file them.
If I can start, maybe there is a misconception 4.5 here as well, because when we see a lot of pitches and things, they have their patent life, and they have often included the 5 years patent time extension, right? So there is some sort of laws now in that, because the drug development takes some time, that you can get a patent time extension, right, when you get the product approved. Now the thing is that the caveat that not everyone seems to realize is that for you to actually use that vehicle or the technicality, your drug actually has to be approved by FDA before your patent expire. And we have seen many cases recently where kind of their estimated approval year in 8 years happens to be the same date that their patent expires. And sometimes there are some slight delays in drug development. So that means that you can push that out, and then you don't have your extra 5 years. So that's also kind of, patent early is good on one end, but if your product actually going to be worth something in the end, you kind of need to have a few years, on the back end of the development as well. Which
and you can only do that for one patent as well. So as much as you can say, I can add 5 years onto every patent I filed, you actually got one approved product, you can only do that for one patent as well, which makes
So no, there are benefits, but there are also some kind of risks with patenting too early. So I think everything in moderation.
If a company had no patents yet and they hadn't even started the patenting process, so they're going for pre-seed investment or seed investment, would you want them to have at least one sort of patent pending? Just then you could call the shots on them, or you have with it?
No, you don't need that. I mean, they have to have a plan. The company needs to have a plan saying this is what we intend to patent at some point in time. That's fine, but of course they can't. We sign an NDA, or actually Industrifond doesn't sign NDAs, but that's a different question. But I mean, we look at things that are confidential all the time, so you have to trust us that we keep things confidential, because even if the patent is not submitted, we need to look at the data. Otherwise, we can't make an assessment if this is investable in the first place, right? So
from my perspective also, this also translates over to the next misconception on you want to get your patents granted quickly. That's also part of this equation, isn't it?
Yeah, I mean, when you come to that stage that your patent has been deemed, when you're getting the letter from from Munich saying that your patent is about to be approved. There are many good reasons and ways to kind of try to postpone that a little bit, because then you kind of know that your patent is fine, it's going to be granted, and at that point in time there is no rush to actually get it granted, because again then you're getting into the national phase and the money starts rolling. So you kind of want to get to the stage where you know it's going to be approved as reasonably quickly, but then the actual approval doesn't hurt if it takes a little longer before you have to take the big costs. Karin, you have any medtech take on this?
Yeah, I think my take is don't look too much on what your neighbor has done, because that's not necessarily applicable for you and your space that you're operating within. And we have in Sweden and in Norway with the clusters, and we have a very healthy environment to actually get support, get IP support included into the different incubators, etc., that we are operating within. So I guess that's where you get that first support to start your journey, but don't rush for the sake of it. Because as you say, I mean, we've seen many companies in our stage when the patents are actually running out, where we see that they only have a window of 2 years before they need to be acquired by the company who's actually either has got the conflicting patent or just can't be in the business anymore. So that's very critical when you get to the later stages.
Right. Well, as was just mentioned, this topic does overlap with the next one, which is the need to get patents granted quickly. I'll hand over to Tom for that.
Yes, so I should whiz through this quite quickly, but yeah, so you want to get your patents granted quickly is the misconception. And there are reasons to want to get a granted patent quickly. It does come up as an issue on a reasonably regular basis for us. You can't actually use a patent against someone who's been granted. A very broad granted patent can be a very strong deterrent to competitors, and it can give investors more certainty about what they would be investing in. Though, as Frederick says, you can sometimes get the answer without having to go through the formal steps of grant. There are downsides having granted patent as well, though. Once you've got a granted patent, its scope can only be narrowed, or there's more flexibility when you've got a granted patent application. So once you've got a patent granted, competitors will know what they can't do, but also what they can do, so they can spend time devising workarounds, things that miss the wording of your claim, which are still commercially valuable to them. And your own product or your own sort of whatever you're doing may change during development, and you may find that actually it drifts slightly in a way that isn't covered by your granted patent, just because some things come up which you couldn't have anticipated in advance. So for this, a patent application is much more flexible, because if your own product drifts or your competitor's product come out and they're not what you're expecting, you've got scope to vary to cover those. The uncertainty of patent application can actually make freedom to operate analysis harder for competitors, because they don't quite know exactly what you're going to have, even though they don't. Even though it's not sort of the bad news for them that you've definitely got granted patent protection, you might get it, and they're not going to want to start doing something and then just have to stop doing it again when your patent is granted. So uncertainty can actually make things worse in the freedom to operate analysis. You might be hoping to get very nice broad protection and not sure when an examiner's going to actually allow it or not, and you can defer the bad news that the examiner will say no if you don't get your patents granted quickly. And finally, to say one way to sort of try and get the best of both worlds is to use divisional or continuation applications, just different words for the same kind of thing. So further applications you file from your existing application. So one strategy is to get a narrower patent granted quickly, but have a divisional application to pursue broader protection, which you keep pending. And the other disadvantage, which is the one we were talking about, and is a key one, is bring forward grant, brings forward costs. All the examination process is brought forward, so all the costs involved in that. But particularly, for European patent applications, and for sometimes I've had cases where it's almost bad news that the application's been allowed, because there can be very significant translation costs you end up with individual patents in a different country want to increase renewal costs. And if you are going to go down the divisionals route, you'd need to follow those 4 grants. So bring 4 grant also brings 4 costs of those. Yes, so but
just for the sake of keeping the time, we will finalize exactly at 2 o'clock our time. So maybe you would go through the 6th misconception as well, since we did discuss a little bit, and then we do the entire discussion if you have any points after that.
Okay.
I can just quickly answer Jeanette's question that she has in the chat about the perfect stage of filing a patent, because it's very easy to answer. Then the answer is it depends. So it depends on where you are in you need to know your chemical space or your protein space or whatever. If you are in a super competitive field and you think you have something that is close but outside everyone else's patent, you probably should file as soon as possible. If you are in a chemical space where there's more room and it's not the GLP-1 agonist peptide that you're developing, but something different, you probably are better off waiting a little longer. So it all depends on, and that is, you need to know your environment you're living in, even for patents.
Thank you, Frederick. So then the last misconception we often come across is that people believe they need worldwide protection for their invention. And in some ideal world, maybe that would be possible. If you've made an invention, why shouldn't you be able to have a patent around the whole world? And the reason really is one of practicality and mostly cost. So patents are territorial, so each country has its own patent in the end. There isn't actually such a thing as a worldwide patent. And if you actually end up with a patent in every country, that is just prohibitively expensive and, in fact, unnecessary. So really, it is, again, it depends. And you need to consider really who you want to stop carrying out your invention. There are 3 main categories of people. So manufacturers, sellers, and consumers. And depending on what your invention is, one or more of these might be the most dominant. Manufacturers, you know where they're going to be. Can they change country is a question to consider. You might know where they manufacture, and they will then be the places to go for. Sellers, they are probably a very important set of people to stop, and they will probably be quite near the consumers. And of course, the consumers are where they are, and they're not going to move. So that then focuses on where the invention is going to be used. And you may be able to get more useful patent protection more easily by covering fewer countries than you might think. So consumers are always going to be quite important. So it's the countries with the biggest markets that matter most. And for specialist products in particular, if you can't have the major markets, there might not be any point in a competitor trying to market their products anywhere. So you can sometimes have useful protection in Europe, for example, just by covering the 3 or 4. Often people want to talk about the big 5 European territories. And then you don't need to go for all the small countries as well. It's always worth remembering that importation is also an act of infringement. So run through that fairly quickly. Quickly hand over to the investors again, then we can move on to any more general discussion or questions.
My quick comment on this is it's all dependent on where your customer is and where where this product is going to be sold. So that's the alignment you should have between your market access plan and your IP strategy.
Yeah, I seem to have a lot of surprising number of conversations about the problems of manufacturers moving factories, and I was thinking, they're not the ones to be stopping, it's the consumers that are the ones to stop.
In a small number of fields, there's perhaps I think sort of semiconductor manufacture is a very small number of manufacturing sites around the world, but that's quite rare. So I think here where we're talking life science things that treat people, be it drugs or tech, the consumers will be the most important.
And this is also an interesting topic for your crystal ball. I worked at Pharmacia 25 years ago. At that time, we didn't include China in our patent application because China 25 years ago was not considered a market for drugs. Now, obviously, that has changed a little bit over the years, and now you can argue that maybe some of the countries that we today do not really see as typical consumer markets. Well, 20 years from now, they actually might be, depending on where the progress is taking us. The other problem with the worldwide is, of course, that some of the countries you probably should avoid having patents in. I came across a few cases this year where they have active patents in Russia. And technically, you cannot do that because that means you have to transfer money to Russia, and you're not allowed to do that with international sanctions. And when then the company said that, well, we found a workaround by a bank in Kazakhstan or something, that doesn't really add to the case in our reviews. That they are good at rounding sanctions is not something to have in your books. So not all countries are the same.
No, that's right. Right. Well, and then maybe I'll pass this back to the investors if that's okay first. Are there any other sort of more general points you'd like to just highlight in the last 2 minutes?
Maybe just one point from the biotech standpoint. I mean, is it called novel chemical entity, NCE patents? That's everything you need. That's everything you want. Because if you don't have that one, you will always start every discussion as why don't you have an NCE patent? And it is possible, but it's a really, really deep hole to dig yourself out of if you don't have an NCE patent. So please get one of those. Sorry? Sorry, Karin?
No, I just said the floor is yours, Hanne-Mette.
Yeah.
Yes, we are approaching the deadline. So, Teresa, you're finalizing, aren't you? We would love to hear more of this, I have to say. So,
yeah, I think it was a really good discussion, and we had some engagement in the chat as well. So that's very good. It's always very nice to sort of get the blunt truth from the people who actually evaluates things on the other side. So I want to thank both you, Karin, and Fredrik for being very direct and open and honest in your feedback, and of course to Paul, Tom, and Julia for drafting up all of these misconceptions and allowing us to have this good discussion here today. So after the webinar today, we will be sending out an email to everyone who signed up. You will get a link to the recording from today. We will also submit that on our web pages, and we will also include contact information for Julia, Paul, and Tom. So you can reach out to them, and if you have any further questions and want to discuss your case, you can feel free to start a dialogue there. So, and I just want to say thank you on behalf of the clusters, Hanne-Mette.
Yes, thank you so much. And we really have appreciated having it today.
Thank you
Thank you for the invitation.
Yeah, cool.
Thank you so
Our
much.
pleasure.
Thanks for having us. Thank you.
Have a
Bye-bye.
nice
Bye.
day.